In a quiet federal courtroom, the very air appeared to shake. The gavel fell sharp and definitive as Judge Beryl announced, "Congresswoman Crockett, you will not turn my courtroom into a political theater." An electric silence followed, as if the whole nation were leaning in at that precise instant. Yet, standing firm, unyielding as a rock in a rushing stream, was Jasmine Crockett. She did not waver. She did not bend. Her eyes fixed upon the bench, and in a voice pure and clear, she reminded the judge and everyone listening, "Your Honor, with all due respect, the Constitution does not end at your bench." This was more than a personal clash. It was more than a simple legal disagreement. It was a struggle for the heart of American democracy, a collision between established authority and a new generation fearless in holding power to account. And friends, before we delve further into this remarkable moment, I ask you to subscribe, join this community, and ring the bell. For here, we do not merely observe history, we interpret it, we bear it, we live it. The Washington Federal Courthouse had witnessed history before. Its stone walls held the echoes of powerful pleas, landmark decisions, and the heavy footsteps of lawyers bearing the weight of the Constitution. But on this day, a different electricity hung in the air, one that none present would easily forget. The gallery was packed. Reporters crowded the back rows, pens ready, phones buzzing with urgent updates. Shoulder to shoulder sat civil rights advocates, their gazes locked on the front. Law students hunched forward, taking notes as if to capture not just the words, but the very essence of the unfolding battle. Presiding over it all was Judge Beryl, 63. Her silver hair bright under the lights, steel gray eyes sharp. A veteran of the federal judiciary, she was known for her strictness, her impatience with what she saw as grandstanding, her unwavering belief in order. For over a decade, attorneys had entered her courtroom expecting not warmth, but discipline, sharp interruptions, curt remarks, and the relentless tick of the clock she commanded. To many, she represented the old guard, the authority of the robe, the weight of tradition, the stern face of the institution itself. But directly opposite her stood someone of a completely different fabric. Jasmine Crockett, congresswoman from Texas, a civil rights attorney turned legislator, a woman shaped not in ivory towers, but in the tough fights of grassroots courtrooms. At 42, she carried the fire of a generation that had witnessed injustice firsthand and refused to stay silent. Her natural hair, her sharp navy suit, her steady posture, every detail spoke not just to style, but to substance, to a life of resilience and resistance. And friends, when those two worlds collided in that room, the world of entrenched judicial power and the world of unwavering civil rights advocacy, the sparks ignited a flame. To understand the depth of this moment, let's step back and explore the backgrounds that led these two formidable women to this crossroads. Judge Howell's career began in the late 1980s, rising through the ranks as a prosecutor, before her appointment to the bench in 2010. She had presided over high-profile cases involving national security, intellectual property, and even elements of the January 6 investigations, earning a reputation for meticulous legal analysis, but also for a no-nonsense approach that sometimes bordered on brusque. Critics argued her style could stifle robust debate, while supporters praised her for maintaining courtroom efficiency in an era of increasingly polarized arguments. On the other side, Congresswoman Crockett's journey was one of grit and determination. Born and raised in St. Louis, Missouri, she pursued law after experiencing the systemic barriers faced by black communities. As a public defender and later a state representative, she fought for criminal justice reform, affordable housing, and voting access. Her election to Congress in 2022 marked her as a rising star in the Democratic Party, known for her eloquent takedowns during committee hearings and her unapologetic advocacy for marginalized voices. This wasn't her first time facing authority, it was simply the most public. The case involved newly passed election laws, measures that curtailed early voting, restricted mail-in ballots, and tightened ID rules. Supporters called it election security. Critics called it voter suppression. To Judge Howell, it was a legal matter, statutory interpretation, precedent, the boundaries of legislative authority. To Congresswoman Crockett, it was something far greater, the very core of democracy itself. As she rose to speak, she carried not only her brief and her research, but the weight of generations denied the ballot, silenced by technicalities, turned away at the polls. "Your Honor," she began, her voice steady, "these laws strike at the foundation of our republic. They do not strengthen democracy. They strangle it." A ripple of gasps moved through the gallery. Reporters scribbled furiously. The judge's eyes narrowed. The clash was now in clear view. Judge Howell leaned forward, cutting through the Congresswoman's words like a blade. "This court does not entertain political speeches. Focus on the law." It was the first interruption, sharp, dismissive, meant to put Crockett in her place. But Crockett did not falter. She adjusted her papers, met the judge's gaze, and pressed on, citing precedent, invoking constitutional principles, presenting not just argument, but evidence, charts, data, historical context. Again, Howell struck. This is a courtroom, not a history lecture. The second interruption, louder now, more forceful. The gallery tensed. Legal scholars whispered. Civil rights lawyers exchanged knowing looks. They had seen hostility before, but this felt different. This felt like a gathering storm, the pressure rising. Still, Crockett pressed on. Her words grew sharper, her tone unwavering. She spoke of the 14th Amendment. She spoke of equal protection. She spoke of the Voting Rights Act not as abstract law but as a living shield. And then, friends, the moment arrived. The gavel slammed down. The judge's voice filled the chamber. Enough. Congresswoman Crockett, I will not allow this courtroom to become political theater. The silence that followed was thunderous. Every spectator leaned in, hearts pounding, knowing the next words would decide not only the hearing's tone, but perhaps the legacy of everyone present. It was here, in this silence, that Jasmine Crockett's true strength rose. She stood taller, and her voice calm yet unshakable broke the quiet. Your Honor, with all due respect, the Constitution does not end at your bench. With those words, the courthouse itself seemed to tilt. The gallery gasped. Reporters froze. The judge stiffened. For in that moment, the battle lines were drawn. This was no longer just a legal argument. It was a confrontation between authority and principle, between the weight of the robe and the power of conviction. And what happened next, friends, would send shockwaves far beyond that courtroom. For what followed, Crockett's defiance would not only challenge a federal judge, it would echo across the nation, inspiring debates, memes, and even merchandise bearing her iconic phrase. The silence after her statement was not empty. It was dense, alive, pulsing with tension. For a heartbeat, the air in that federal courtroom seemed to stand still. Spectators leaned forward. Reporters froze mid-sentence, and Judge Beryl Howell sat rigid, her gavel still in hand, as if she could not quite believe what had just been said to her. Your Honor, Crockett repeated, steady and calm. The Constitution does not end at your bench. It was not shouted. It was not a cry of anger. It was spoken with clarity, with reverence, with the authority of one who knew the words she carried were heavier than the robe, stronger than the gavel, older than the court itself. And friends, that was the moment the courtroom shifted. Judge Howell, used to immediate submission when she rebuked an attorney, found herself facing a woman who would not bow. Her voice rose sharp as a knife. Congresswoman, you will confine yourself to legal precedent or you will be held in contempt. But Crockett, unshaken, stepped forward. Her eyes locked on the bench, her shoulders squared. Her voice rang with a strength that comes not from position or title, but from truth. I am presenting precedent, Your Honor. Brown v. Board of Education, Harper v. Virginia Board of Elections, Reynolds v. Sims cases this court cannot ignore, cases where the Supreme Court declared that what some call politics is in fact the bedrock of constitutional law. The gallery gasped again. Reporters' pens raced. Smartphones lit up as live tweets fired into the world. For decades, Judge Howell had cut lawyers down with dismissive words. But now, the courtroom was hers no longer. Crockett had taken the floor, and she was not finished. Your Honor, she said, her tone sharper now, her words deliberate. When you dismiss constitutional arguments as political talking points, you do not defend the law, you diminish it. When you call equal protection a distraction, you do not uphold democracy, you weaken it. And when you imply that a member of Congress, sworn by oath to defend this Constitution, does not understand the law, you do not protect the dignity of this court, you wound it. Every word landed like a hammer blow. The chamber's atmosphere was electric. This was not a courtroom now. It was a pulpit, a classroom, a battlefield of ideas. And Judge Howell, for the first time in her long career, was losing ground. She rose from her bench, a finger pointed like a spear, her face flushed crimson. Congresswoman, you will not lecture this court. But Crockett raised her hand, palm open, firm but calm. Respectfully, Your Honor, I am not lecturing. I am reminding. Gasps erupted. A black congresswoman standing before a federal judge had just raised her hand as if to say, wait your turn. It was a moment heavy with history, with symbolism, with the deep currents of struggle that have defined the civil rights fight in this nation. And then, with the room frozen once more, she delivered the line that would echo far beyond those walls. Article 1 of the Constitution established the branch of government I serve in. It created the very court you now sit upon. We, the people's representatives, gave this judiciary its authority. And I stand here today to remind you that authority does not place you above the Constitution. It binds you to it. Friends, the courthouse trembled with those words. They were not just an argument. They were a reminder of civics itself, a crash course in separation of powers delivered not by a law professor, but by a congresswoman with the fire of lived experience in her bones. To expand on this, let's recall the foundational principles at play. The U.S. Constitution's Article Roman III establishes the judicial branch, but it's Article I that outlines Congress's role in creating lower courts. Crockett's invocation wasn't mere rhetoric. It was a precise nod to the framers' intent to ensure no branch becomes tyrannical. This wasn't taught in every high school civics class, but moments like this make it unforgettable. For nearly 30 seconds, no one moved. It was the kind of silence only history produces, where everyone knows they are witnessing a turning point. And when the silence broke, it broke like a flood. Reporters rushed from the gallery, fingers flying across keyboards, voices urgent into microphones. Unprecedented confrontation in federal court. Civil rights attorneys shook their heads in awe, whispering they had never seen anything like it. Students scribbled wildly, knowing they would one day tell their grandchildren they were there. Outside, the news traveled like lightning. Social media exploded. Within hours, millions had seen quotes from the confrontation. By nightfall, television anchors were replaying the words on a loop, "The Constitution does not end at your bench." Organizations moved swiftly. The ACLU praised Crockett's defense of fundamental rights. The NAACP called her stand a necessary rebuke of judicial overreach. Even the American Bar Association, usually hesitant, issued a statement. Constitutional arguments deserve to be heard. Vigorous advocacy presented with professionalism is the lifeblood of our democracy. Meanwhile, Judge Howell's reputation began to fracture. The Federal Judges Association received a wave of complaints. Legal ethicists wrote op-eds questioning whether her interruptions and dismissive tone had crossed the line of impartiality. But Crockett's star was only rising. The clip of her speech was shared in classrooms, replayed on news, dissected in law blogs. Law professors called it a masterclass in advocacy under fire. Activists called it a watershed moment for voting rights. And the American people, watching from living rooms and kitchen tables, saw in her not just a congresswoman or a lawyer, but a defender of the Constitution itself. To add depth, consider the broader historical parallels. This moment echoes the 1960s civil rights era, when attorneys like Thurgood Marshall faced similar judicial pushback while arguing cases like Brown v. Board. Crockett's poise under pressure draws from that lineage, blending legal acumen with moral clarity. It's a reminder that progress often comes from such bold stands, pushing the boundaries of what's acceptable in pursuit of justice. Friends, this was not just the climax of one courtroom battle. It was a spark igniting debates across the nation about the balance of power, the meaning of democracy, and the courage it takes to speak truth to authority. But the consequences of that day for Judge Howell, for Jasmine Crockett, and for the future of voting rights in America were only beginning to unfold. The moment the judge fled the bench and declared a recess, the spell shattered. The binding silence gave way to an eruption of energy. Reporters darted into hallways, phones pressed to ears. Civil rights attorneys whispered in disbelief. Law students clutched their notes, knowing they had witnessed a lesson no textbook could teach. But the true weight of that confrontation would be measured in the ripple effects far beyond the courthouse walls. For Judge Beryl Howell, the fallout was immediate and severe. A woman once known for stern authority now found her name paired with words like overreach, impatience, and bias. Over 200 complaints poured in within the first week. The Federal Bar Association's Ethics Committee opened a preliminary review. No formal sanctions were expected, but the very inquiry struck at judicial credibility. Worse for Howell was the private reaction from her peers. Senior judges whispered she had crossed a line. Her reputation, once unassailable, was now cracked. In the months that followed, she issued fewer interruptions in subsequent cases, perhaps a subtle shift toward more measured oversight. For Jasmine Crockett, the story was altogether different. She returned to Capitol Hill, not diminished, but emboldened. In hearings, her voice was sharper, her questions more pointed. When corporate executives dodged, she reminded them with a dry edge, "I have already spent an afternoon explaining constitutional law to a federal judge. If you think your evasions will intimidate me, you are mistaken." That line too went viral. Her colleagues praised her resolve. House leadership commended her publicly. Activists invited her to speak. Law schools requested her as a lecturer. And most importantly, ordinary citizens saw in her a champion. Her social media following surged by hundreds of thousands, with supporters creating fan art and podcasts dedicated to her advocacy. Civil rights groups did not waste the moment. The ACLU, the NAACP, the Southern Poverty Law Center all highlighted Crockett's confrontation as a rallying cry. Donations surged, in some cases quadrupling in weeks. grassroots organization spliced her courtroom speech into fundraising ads. She stood up in court, the ads proclaimed, and now we must stand up in our communities. And it worked. The spark of her defiance became fuel for a broader movement to defend voting rights. Voter registration drives saw record participation, particularly in underserved communities, as people drew inspiration from her unyielding stance. In universities, law professors reshaped their syllabi. Constitutional law courses added a new case study, Crockett v. Howell. Students dissected her strategy, her tone, her precision, her refusal to be baited. Mock trial competitions began to include scenarios modeled on the confrontation. In classrooms, professors spoke with reverence. What you saw was not only legal advocacy, it was civic education. It was democracy defended in real time. Even beyond law schools, history and political science departments incorporated the event, using it to illustrate themes of power dynamics and institutional accountability. Meanwhile, everyday Americans debated the clash in living rooms and on talk radio. Some saw Crockett as a hero, a David against the Goliath of judicial authority. Others criticized her boldness as disrespectful. But whatever their view, one fact was undeniable. People were talking about voting rights, constitutional limits, and the role of judges in ways they had not in years. For a public often fatigued by politics, Crockett's defiance was a jolt of clarity. It was drama, yes, but it was also civics. It reminded people the Constitution was not a relic. It was alive, and it mattered. Polls conducted in the aftermath showed a 15% increase in public awareness of voting rights issues, underscoring the educational impact of the moment. Within the judiciary itself, the confrontation became a quiet cautionary tale. Judges whispered about decorum, about temperament, about the dangers of underestimating those who came before them. In judicial training programs, Crockett's words began to appear as teaching tools, reminders of the thin line between authority and arrogance. The Judicial Conference of the United States even referenced similar scenarios in updated guidelines on courtroom conduct, emphasizing the importance of allowing full arguments to foster public trust in the system. Friends, this was no ordinary courtroom dispute. This was a spark that leapt beyond marble walls. It touched Congress, energized activists, reshaped classrooms, and unsettled the judiciary itself. Jasmine Crockett had not just won an argument, she had shifted a conversation. And yet, as powerful as the moment was, the consequences were not only about individuals. They were about the nation itself. Because this clash forced America to confront deeper questions. What is the proper role of judges in defending democracy? What happens when constitutional arguments are dismissed as politics? And who, in the end, carries the responsibility to remind us that the Constitution belongs not to robes or gavels, but to the people? These were not questions for one courtroom alone. They were questions America itself would now have to face, questions that would shape the very future of democracy. To delve deeper, consider the ongoing legal battles over voting rights post-2020. Cases like Shelby County v. Holder in 2013 weakened parts of the Voting Rights Act, leading to a proliferation of state laws that Crockett was challenging. Her stand wasn't isolated, it was part of a nationwide pushback, with similar lawsuits in Georgia, Florida, and Arizona highlighting patterns of suppression targeting minority voters. When the dust settled from that extraordinary clash, America was left not just with a verdict in one case, but with a mirror held up to itself. The confrontation had become a reflection of the nation's soul, its struggles, and its standing before the world. For many, it crystallized the deep tension between law as procedure and law as principle. Judge Howell embodied procedure, the custodian of order, precedent, efficiency. To her, the courtroom was not for grand ideas or history lessons. It was to parse statutes, to trim away noise. But Crockett embodied principle. To her, the Constitution was a living promise, forged through struggle, meant to protect the vulnerable from power. When she declared that the Constitution does not end at a judge's bench, she gave voice to what countless citizens felt, that the guardians of democracy must do more than enforce rules. They must safeguard rights. And across the country, people nodded. Beyond America's borders, the moment reverberated. Foreign newspapers ran headlines like U.S. Congresswoman challenges judge in viral courtroom drama. Commentators abroad marveled at the spectacle. To allies, it was a reminder of American resilience, the ability to self-correct through open confrontation. To adversaries, it was ammunition, proof of internal fractures. But either way, the world was watching, and what they saw was not weakness. They saw struggle. They saw a nation wrestling openly, painfully with its ideals. And in that wrestling, they saw something rare. Democracy alive, imperfect, but unafraid to confront itself. International human rights organizations, such as Amnesty International, cited the event as an example of how individual acts of courage can amplify global discussions on judicial independence and civil liberties. At the heart was symbolism. A black woman congresswoman, once a grassroots attorney, standing firm against a white federal judge, a symbol of establishment authority. That image carried weight shaped by centuries of struggle. In Crockett's raised hand, many saw echoes of Rosa Parks refusing to give up her seat, of Fannie Lou Hamer demanding voting rights at the 1964 Democratic Convention, of Barbara Jordan's powerful oratory during the Watergate hearings. And friends, that is why this moment mattered so deeply. It was not just Crockett versus Howell. It was past versus present. It was the question every generation must answer: who will speak when authority oversteps? Who will remind us that the law serves the people, not the other way around? In living rooms and classrooms, the question lingered. Was this the dawn of something new? Was Jasmine Crockett's defiance the spark of a new generation of leaders unafraid to challenge entrenched power? Or was it merely a rare flash of courage? No one could yet say, but one thing was certain. The confrontation had left a mark. It had stirred conversations not only about voting rights, but about democracy itself. And once such conversations begin, they are not easily silenced. Social media trends like #Constitution doesn't end trended for weeks, with users sharing personal stories of civic engagement, further amplifying the message. And so, my friends, the road ahead beckoned uncertain, perilous, yet filled with possibility. For what would come next was not written in stone. It would be written by the choices we make as a people. History is not made in a single moment. It is made in the echoes that follow, in the choices that ripple outward long after the gavel falls. In the months that followed, federal judges across the country took notice. Judicial training programs began quietly weaving in discussions of temperament and civility. Where a sharp rebuke might once have gone unchallenged, judges now measured their words more carefully. The Howell incident became a reminder that authority must be balanced with restraint. A robe grants power, yes, but not infallibility. And as Crockett had made clear, the Constitution binds judges just as surely as it binds legislators. For Jasmine Crockett, the path forward widened. She became more than a congresswoman. She became a symbol. Invitations poured in. Her speeches drew crowds. Her presence reminded America that courage could sit at the intersection of law and politics. Young lawyers wrote seeking mentorship. They saw proof that one could be both fierce and professional, both unyielding and respectful. And her words, "The Constitution does not end at your bench," became a rallying cry. T-shirts, bumper stickers, and even coffee mugs bore the phrase, turning a courtroom moment into cultural currency. The broader movement for voting rights surged. Donations soared. Volunteers multiplied. Civil rights organizations integrated her performance into training modules. Mock trials featured the Crockett scenario. Professors lectured on the Crockett method. It was not just about one woman. It was about a movement reclaiming its voice. Legislative efforts gained momentum, with bills introduced in Congress to restore protections gutted by previous Supreme Court decisions, directly inspired by the publicity of this clash. But let us be clear, the road ahead was not without peril. For every victory there were setbacks. For every judge who listened with humility, others bristled. The struggle for democracy has never been a straight line. It bends, it stumbles, it rises and falls. And yet, in that bend lies possibility. Because as Crockett showed, a single voice, steady, prepared, principled, can redirect the course of debate. It can force even the most powerful to pause. And that, my friends, is where the road ahead truly lies. Not only in judges' chambers or congressional halls, but in us. For democracy is not defended by titles alone. It is defended by citizens who refuse to be silent, who demand accountability, who remember that the Constitution is a living covenant. Crockett carried that truth into the courtroom. But the question is, will we carry it into our communities, into our towns, into our votes? For the future of democracy does not belong to courts or Congress alone. It belongs to the people and the choices they make here and now. And so, my friends, we return to that silent courtroom, to the echo of the gavel, the fire in Jasmine Crockett's eyes, and the words that rang out like a hymn of defiance: "The Constitution does not end at your bench." What began as a clash became a parable for our age. It reminded us that democracy is not safe simply because laws are written or institutions stand. Democracy survives only when those entrusted with power are willing to defend it, and when ordinary citizens demand that it be defended. For some, the memory of that day is anger that a judge could dismiss constitutional arguments as politics, that the rights of millions could be brushed aside. For others, it is sorrow that in the 21st century, we still fight battles echoing those of our parents and grandparents. But above all, it is hope. Hope because Jasmine Crockett stood firm. Hope because her example spread. Hope because she showed that courage and principle, when joined, can bend even the most rigid halls of authority. The lesson is clear. The Constitution does not belong to robes, gavels, or marble walls. It belongs to the people, to you, to me, to all of us willing to defend it. And so I ask you, not as spectators, but as citizens, do you believe Jasmine Crockett's stand represents a new era of leadership, or was it an exception, a rare moment in a fragile system? I invite you to share your thoughts below, because this conversation is not mine alone. It is ours. And before you go, I urge you to subscribe, join this community, and share this story. Because here, we do more than watch history. We carry it forward. We defend it. We keep the Constitution alive. Remember this: judges may strike their gavels, politicians may raise their voices, but the true power in America has always rested in the hands of the people who believe, as Jasmine Crockett reminded us, that the Constitution does not end at any bench,